Okay, we're live. Welcome everyone to our event, AI Hiring Regulations Unraveled. We're really excited to have with us a guest to talk about this really important and very timely topic. His name is Zach Long of Conductor AI. This is about the new New York Local Law 144. It's called the AI Law, and it's basically goes into effect right now. So who better to talk to us than Zach? He heads up Conductor AI, which is an AI compliance platform. So a few things before we get started. We are streaming this on LinkedIn, Facebook, YouTube, our Facebook page, and a group. So you are free to comment. If you comment and we see your comment, we're going to try to pick up your questions at the end of this. We're going to try to keep this to around a half an hour and then leave about 15 minutes to answer your questions. And I'm sure you might have many. So on to us. Zach, we're going to go over in a few minutes and he can introduce himself. My name is Miles Jennings. I'm the CEO of recruitercom, which is a hiring platform. We offer recruiting solutions for employers. I encourage you to go to www.recruiter.com to learn about our hiring solutions. Also, we run the AI Exchange group on LinkedIn. A lot of you are probably members of this group. It has a new focus solely on artificial intelligence. There's just so much going on, so many new developments. It's actually almost impossible to keep up with it all. So we created this discussion group. There are over 1 million members now, and it's very active. We're looking forward to developing lots of great conversations in that group and also having really nice events like this one with Zach. One note before we start, this is kind of a compliance and legal topic, so I thought a quick disclaimer might be a good idea. I'm getting the thumbs up. This is not legal advice, although it might seem like it. This is just for general and informational purposes only. We're trying to help you make sense of this new regulation, see how it applies, and really just discuss the industry and how things are changing with AI compliance and regulation. It's a great topic to discuss. But of course, when you're making decisions, talk to your legal counsel, talk to more official people than we are. So Zach, why don't you introduce yourself and your company a little bit? We'll forgive me. I'm going to ask you a couple of questions about your background and about Conductor, because I love talking about startups and I love hearing about the genesis of the idea.
Yeah. So thanks. So I'm Zach. I'm the founder of Conductor AI, and we are an AI compliance firm. We specialize in the nascent but rapidly growing world of complying with AI regulations. AI is hot, but hot on its heels is our governments that are passing laws to govern what you can and cannot do. So yeah, thanks for having me, Miles.
Zach, when did you start this company? When did you get into this area in general? When did you get interested in AI and compliance and everything you do?
So yeah, I've been working in AI space for many years now. I worked before starting Conductor AI. I worked at Palantir Technologies, which is a large multinational company with a specialization in AI, for 8 years. When I left, I headed up our AI work in the Department of Defense. And I left to actually, based upon some of the problems that I was seeing and encountering, which is just around how tricky handling and navigating some of the compliance hurdles that we had to deal with were. And I realized that this was just going to be that, as the interest in AI boomed, I realized that that governments were very acutely aware of what was going on, and that this isn't 2012 anymore. Tech is not this glory child save all, and people are afraid, and perhaps rightly so, and are going to be regulating AI very closely. And so earlier this spring, me and my co-founder, who worked at a compliance tech company called Prevail Technologies, we started a company, Conductor AI, to help companies navigate this. And the first big US law regarding AI regulation is New York City 144. So yeah, so that's what we're going to talk to you about, that, and then any other AI regs that are coming down the pipe, of which there are many.
Probably many.
Yeah.
And for anyone looking out there to start a business, get into startups, this is what you want to do. You want to do the whole, skate where the hockey puck is going. And I think, Zach, you're doing that perfectly. So this industry, if you can call it an industry, AI compliance, it basically doesn't exist right now, but it's going to exist. So you're seeing that it's going to be a trend. The wind is at your back, and this is going to be a really important area. All of the major AI companies are themselves calling for greater compliance. People are trying to ensure that diversity, et cetera, are maintained in the hiring process. There's going to be a lot of pressure on governments to regulate companies. There's also a lot of fear about AI, and so there's going to be a lot of pressure on rulemakers to basically do something about this. And here you are starting this company that it provides exactly the antidote to that. So kudos, and everybody follow this lead. Develop solutions to the trend that will happen, not the trend that has happened.
Well, thank you for having me. That is certainly my bet as well, and that was a very warm introduction. So thank you. Yeah.
Thanks, Zach. All right, let's get into it. NYC local law 144. Tell us about it, Zach.
Sure. So New York City local law 144. This is America's first punitive AI specific piece of legislation. And I say punitive because there have been other laws around AI before, but this piece of legislation carries specific punishments for noncompliance. And it also sweeps up a lot more technology than previous laws. So Illinois and Maryland passed legislation regarding AI in facial recognition software and interview processes back in they were introduced in 2017, passed in 2018. But so that was, previous legislation, but that was very narrow, perhaps even arguably targeted at one specific company. And now this most recent piece of legislation, local law 144, has expanded the aperture quite a bit. It governs the use of automated employment decision tools, or as it calls them, AEDTs, in the workplace. The law is sort of misnomered as like the AI bias law. It's really, AI is, I think kind of the underlying fear here, but the law actually applies to anything that's really using any form of statistical process to stack and rank candidates. And we'll go into the specifics in a second, but it's any machine-driven process that used in the hiring process can be an ADT. And the requirement is not stop using this technology. It's you need to get an annual assessment for bias in this software or this technology if you're hiring in New York City.
Great, thanks, Zach. And for those who think that AEDT is an Australian Eastern Daylight Time acronym, it is not. Just to back up here, because that is the main kind of system that is addressed in this new legislation. In AEDT, I want to be very slow about this because I learned about this for the first time, whatever it was, maybe a month ago or so. I'm going to read the definition kind of slowly, and you tell us the easy, sort of the dumb way to think about this. So AEDT, the definition is any computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence that issues simplified output, including a score, classification, or recommendation that is used to assist or replace discretionary decision-making substantially. So to my understanding, this is something that helps you spit out a score, or perhaps stack rank applicants, and kind of maybe not completely bypass the decision, our human decision-making process and resume screening process, but maybe augment it and maybe come before that decision-making process. So tell me if I'm correct, and maybe even simplify it further.
No, I mean that's bang on. The AEDTs can be very simple. If you basically had a piece of software that was just search the entire internet for I want to be nervous about throwing out an example of an AEDT that I'm making up on the spot here that might not be one. But anything that basically automatically sources, rejects, or promotes candidates automatically, and that's one of the key words here, is going to be considered an AEDT. So if it's helping you, if software program is sending you a list of candidates, rejecting a list of candidates, or pushing out of a huge list of candidates 10 up to the top for you to review, it's probably an AEDT. But we'll go into that in a second.
And the genesis for this, if this regulation is a solution, the problem is really discrimination, right? I remember back in, I think it was 2018, where Amazon developed their own AI system for recognizing qualified software engineers. And it turned out it discriminated because it looked back on the last decade of applicants, and it turns out the preponderance of them were male. And so it started saying, hey, if you're part of the women's chess club, you're going to be, it essentially discriminated against you because of the past, right? Yep. So this has been kind of in the conversation for some, in the public conversation for some time now, maybe like 5 years or so, but it's probably coming to a head because AI is just, the real technical use of AI is just picking up so much.
Absolutely. So yeah, so my flow chart for am I using an AEDT is if I am using, and am I using an AEDT that is subject to New York City Local Law 144? If you have a simplified output to rank candidates, or you are automatically sourcing, screening, or rejecting candidates, and you have an office in New York. If you hit 1 or 2 and 3, you're probably using an AEDT under New York City Local Law 144. Right. That's the simplified way.
And one question, so when they define an office in New York City, that means many, many, many companies, not just who are headquartered there. Does this apply if I'm mostly based in Florida and then I have I occupy a WeWork in New York City? Am I under this law?
So great question. Not a lawyer, but the answer is yes. The answer is if you are hiring persons into New York City that have a New York City location and you're using any of this software, it is subject to this law. If your headquarters in Florida and you have a 2-person WeWork, but you put on the job description hired into New York City, that would be subject to this law. If your headquarters is in Florida and it's a fully remote company and that the person happens to be in New York City, so if you're hiring for a remote position, it's Florida-based company, remote position, hiring in New York, actually no. In that case, you're not doing it. But from the example you gave, Miles, where you're saying we're hiring them and they should go into this WeWork, then they would probably be subject to it.
Okay, great. And the question of, am I using an AEDT? So you can look at it yourself, and I think we've developed a good, sort of way for people to think about that. We're not going to talk about specific vendors. There are a lot of vendors that may be classified like that, but we're not going to get into that. But would you suggest that people talk to their, like if they have an applicant tracking system or a sourcing company, what's the first step? Do you think they go to the vendor and discuss this with them? Do they go to more like their corporate legal? Is it a talent acquisition? Like, what's the process that you would recommend for people to start out figuring out if this applies to them?
Yeah, I mean, so 2 answers here. One, I would ask the vendor. From what I've seen, the people that are sort of, in my experience, boots on the ground, the people that are the most acutely attuned to this law are the recruiting software companies, the sourcing companies, those are the types of firms that this law directly impacts, and they've probably had discussions internally about whether they're an AEDT or whether they're not. And if you're using some external vendor or, either as a sourcer, as either you're hiring a company to do sourcing, you can ask them, they'll ask their software vendors, or if you're using a software vendor directly, ask them. They'll probably tell you, and they will, if they don't have an answer by this point where they sort of hem and haw over it, send them to me. But they should probably at this point know whether or not they're an ADT and be able to tell you pretty concretely.
Okay, great. Let's go on.
Sure. So this is a slightly more detailed way of, do I need a bias audit? And I just wanted to pull this up just because this is when we are talking with our clients to actually go through this is what we go through with them. So from left to right here, if you're using, first of all, is the AI software, I shouldn't say AI, is the statistical process being used in sourcing, hiring, or promotion? If, yes or no. Is the software or statistical process making predictions or a score? So does it provide from the letter of the law, score, classification, ranking, or assessment? And does it provide any positive or negative suggestions based upon a candidate's performance? If no in this category, if there's no, I'm going to walk through this table. If there's a no in any column, you don't need a bias audit. Most companies don't need a bias audit. This is, I would say, probably 80 to 90% of companies are not subject to this legislation given their existing hiring practices. And most are going to hit a no somewhere in here.
Okay, that's good. Everybody's hoping for it to get a no on this.
Yeah, I think everyone's hoping to get a no. This is the way that you need to hit a yes in all 5 in at least one column. You need to hit a yes in all 5 of these columns. So is it making a prediction or a score? Are the factors that are being used in this process human or machine created? So what I mean by that is, when the statistical ranking or the similarity score is being produced, were the humans creating that process or not? So to give you an example of something that is not an AEDT, but might sort of hit the rest of the categorizations, if you give someone a multiple choice test that's administered online, so, select A through D and it gives them a score, and your characteristic is, we accept candidates with an over 75% score on this multiple choice test to move on to the next round, that would not be an ADT because the factors that are creating this scoring system are entirely human created. So that is one thing to know, is if you basically can say, here is the exact process that I set up in order to score this, then probably not an ADT.
Right.
Next one is automated or not. Does it automatically serve up candidates or reject candidates? Or does the ranking provided weigh more heavily than any other factor? So what this means is, if software you have configured automatically rejects certain candidates based upon how they respond to something or what they do, that would qualify them in, as an automatic rejection or an automatic promotion. Another one that's a little more subtle is if there is a prospective thing that is sourcing from, let's say, 1 million candidates or a large population of candidates, maybe like all of LinkedIn, all of Indeed, and it is only serving you 15 of those. That is very likely to be an AEDT under this definition, because what it is effectively doing is ranking this list, and you as a human being, you are actually relying on that ranking more so than any other factor, because you are not actually looking at the 1 million people that were not served up by this software. So in terms of the automated or not, this is actually a criteria that hits a lot of sourcing tools in particular, where they pull from a very large list and serve up a more narrow one.
Right. Thanks, Zach. And one other question on the does it apply to me side of things. Is there any type of company size requirement? Some of these things, they spare small companies, some they don't. So do you know the answer?
Simple answer is no. There's no in the
legislation. So it applies to everybody.
Applies to everybody hiring in New York. If you have an office in New York, you're subject to it.
Okay. Sorry, everyone. Sorry to everyone watching.
So the 4 common categories that we've seen, this is, broad strokes here, but a resume screener, automated candidate scoring based upon some test or how their LinkedIn profile looks, automated sourcers. I've talked about that a bunch. And one surprising one is actually coding screens. Coding screens are sort of slightly more, they they're closer to the multiple choice test, but they're kind of not, and they're not because the way that these are often conducted involves the creation of a score that is not derived entirely from human factors, which puts them into the AADT bucket. So these are sort of the four big categories that we've seen. Oh, sorry.
Is a coding screen a test of somebody's software development abilities, like when they're coding into a text box and then it's ranking their code?
Yeah, like a hacker rank or
right.
Not to name companies, but yeah, like one of those types of coding tools that is used to automatically assess the effect, how good someone is doing on a programming test. Those are more involved than a traditional multiple choice test. And the way that those are scored is they tend to be, and this is, broad brush, but they tend to be scored automatically. And for that reason, they would qualify as an AADT under the way the law is written.
Right. Very good.
Before I go to this slide, Miles, do you mind if I show like what a bias audit actually looks like?
Yeah, I think we have perhaps scared a number of people.
Yeah.
When I saw this, I thought, oh, it's actually not that bad after all. So that would be great.
Okay,
so
cool.
You're going to present that?
Yeah. So I'm going to share. So all of that talk about like, okay, this is a scary thing, and I think people hear audit and think, oh, okay, this is some, deep and thorough thing and I need to avoid it at all costs. This is actually the entirety of a bias audit under 144 that is sufficient to achieve compliance. There are three categories that you need to do. You need to provide sex, race, and intersectional, which is basically sex and race. I can go into like the specifics of how this is done, but this is the entire thing. It's effectively, when we work with companies, there's a little bit of fear and apprehension at the beginning. Like, is this going to be some super expensive thing? They're $2,000. We do $2,000. They're fairly cheap to administer, and this is actually all it is. You produce this breakout of what you are. The selection. This is a selection rate audit, and you produce this impact ratio score. But this is the entire thing that comes out of the audit. The actual audit is basically getting this data and then confirming. And then what I am doing is confirming that you aren't withholding information from me, and this is actually an accurate representation. There's no such thing as passing or failing, which I think is a sort of a misconception. This is a transparency requirement. The thing that you have to do to become compliant with this law is have a link on your jobs board to a thing that looks like this. It would be for your company name, what software you're using, what date it goes live, and that is the compliance requirement, as New York City 144 states it.
Very good. So it sounds less onerous than an SEC audit, which
is less onerous. Yeah,
which is tricky.
Every single company that we've spoken to, they're like, how long is this going to take? And we're like, well, the actual aspect of us producing that statistical report takes about an hour. The entire challenge is getting a representative sample of data from you, and that tends to take like a week, mostly because people don't actually really know where in their systems that information is stored.
Yeah, that was actually my next question for you. When I see, okay, you're going to analyze my data, my first question is, where is that data? So where will that typically be housed, and will employers always have that data readily available for you to audit?
So that's actually been the tricky thing, is that candidly, I wish I could tell you there's some super standardized answer, but I haven't, in my experience, seen one. We've been working very closely with a lot of the vendors in this space because they sort of know, they have like their own structured format of it. But what we've actually seen in a lot of cases is that vendors don't track applicants' sex and ethnicity. So there's sort of an interplay where like the vendors will have the data and be matched to a person, but the actual sex and ethnicity are stored by the company. And that's sort of we have to, when we are helping the vendors become compliant with this legislation, we have to ask for what is called sample data from them. So basically, one of the companies that uses their software will give us a representative sample of sex and gender, and then we can conduct the audit on that.
Okay, very good. All right, so let's move on to sort of the future.
Yeah.
So people watching this right now, some of them are from the New York area, a lot of them aren't. And right now, nothing applies to you if you're not in the New York area. But there is just a lot of pressure to implement these things. And so, what are some of the major trends in the industry and sort of things coming up to watch for?
Yeah, so I think New York City 144 is setting a standard here that other states are likely to follow and actively following. Sort of no surprise, California is very closely mirroring the New York City piece of legislation. California Assembly Bill 331, if passed, has not been passed yet, but is currently in discussion, is set to be a January 1st, 2025 compliance requirement for you need an adverse impact assessment, which has some nuanced differences than 144, but it's pretty similar. One thing to note here, it also sort of mandates that you track gender and ethnicity as well as some other characteristics in order to be able to provide these adverse impact assessments, basically a similar type of thing for the New York 144 requirement. New Jersey A4909, that's currently in discussion. That very much impacts vendors of this software, which says that if you're trying to sell any form of AI or statistics, I keep on saying AI when it's really not, any form of statistically powered recruiting or sourcing technology, you need to have an adverse impact assessment in order to sell it, and then basically hold it up and say, hey, I've done this thing before you provide it to clients. Those laws haven't passed yet, but I think that the California one is likely to pass this year. New Jersey, maybe next year. But they're certainly coming. And those are the US pieces of legislation.
Yeah, so it's really coming down the pike. And I think a lot of employers right now, probably more, I don't have any data on this, but probably more so than ever, they are fully multi-state employers. Yeah. So what happened with us, my company, during COVID, we went completely virtual. We started hiring in lots of different states, lots of different things to think about. And the way that I would kind of simply think about things is to look at California, to look at New York, and sort of tightly regulated, more like compliance-oriented states, and make sure to follow those procedures and kind of look at those. And so that might be something that, sort of a piece of advice for employers right now, because even if it doesn't like apply right now, you might sort of look at those as what's coming down the pike.
Yeah, that would be my expectation too.
Great. So let's talk international for a minute. My eyes aren't good enough to read this, but what are some of the major trends and
yeah, okay. So this graphic is a little too small to read, isn't it? Okay. Well, the point here is in the past 2 years, there have been 17 separate pieces of AI legislation that have gone out in countries all around and continents all around the world. This isn't including state and local legislation. The biggest one, and by far the most, AI is currently not very regulated. It is my firm belief, and AI is going to be very regulated. That is going to happen. And you can see based upon this graph of how many pieces of legislation have been introduced, that more legislation is coming. The most strict of these, that is the most immediate to pass, is the EU AI Act. This is a very, very much more onerous piece of legislation than the New York City bias audit. It's not even close. And hiring, if you're using any form of hiring software, there are meaningful compliance requirements if the EU AI Act passes that you will have to meet. It is considered a high-risk application of AI in the European Union, and it will only apply to people that are hiring in the European Union. But if you're a multinational company that is has maybe some centralized function here, there will certainly be additional compliance requirements for you in order to continue using those products in the European Union.
And when is that possibly coming down?
So it just passed the European lawmaking process is quite long. It just passed sort of its second wicket on, I believe it was June 14th. So a week and a bit ago. It is expected to pass. It is expected to basically become an official piece of legislation by the end of 23 with a go live date set for 2026. However, all of this is, depends on the timelines of the European lawmaking bodies. I would say that January 1st, 2026 is a reasonable guess, but it is not, necessarily clear it's going to happen, what the day is.
Right. Thank you. And we just got a comment in from Andrew here. Dame Wendy Hall is trying to spearhead this in the United Kingdom. So you might know something about that I don't, Zach.
Yeah, so the United Kingdom and the EU are taking very different tacks on this. The European legislation is very strict, has a large number of requirements that companies are going to have to work to meet, while the UK is taking a much more, I would say, permissive approach. The UK does not have is not part of the European Union. It does not have I don't know exactly how things will shake out, but if we can draw any conclusions from GDPR, a lot of corporations, I suspect, will have to adhere to what is considered like the strictest piece of legislation in a global market. And I think the European Union would qualify as that.
Right. Okay, terrific. So we are at 1:30 right now, so we're going to kind of wrap it up. Here's, I'll show Andrew gave you some more information there.
All right. I'll be sure to check that out, Andrew. Thanks.
Okay. And again, Zach, I really, I applaud you for doing something kind of entering into an area of great white space, right? Like it's something that is really going to develop. It's an important topic. It's also a very, I would call it a dry topic. And I think that not to insult you, rather the opposite. I think that many times sort of dry, difficult, boring topics that are like compliance and legal, data science, areas that are very difficult to sort of get your mind around and get excited about, they actually represent tremendous opportunities for entrepreneurs who really can like go into something, become subject matter experts, and really develop into leaders in that field. So really, like, hats off to you, and I wish you the best with it. And it is for a very good, I won't call it a cause, but it is a good process that's needed to help diversity and ensure that all of this AI is kind of developed in a fair way. And certainly hiring is an area that is very sensitive. So tell people how to kind of get a hold of you, and then anything else you want them to know.
Thanks so much. So my company is conductorai.co. My email is zach@conductorai.co. You can also reach me on LinkedIn. If anyone has any further questions here, would be happy to discuss, happy to talk New York City 144 or any of the upcoming legislation. Just want to say this, I am actually just putting my views out there. I am a big believer in the value and the goodness of AI. I also think that you can misuse it. And in my opinion, making sure that companies are actually able to deploy AI, but in doing so within the law, I think is an extraordinarily important and a mission that I believe deeply in. So thank you so much, Miles. And again, conductorai.co, Zach, Conductor AI. You can reach me on LinkedIn. Happy to chat anytime.
Zach, I got a question that came in about the timing. So this is really, I said at the beginning actually that this was a timely notice, and I believe it was July 5th, if that's correct, that it goes into enforcement. And so we are having this right at the right time. And so this person asks, is that actually true? So yes. I don't know the answer to that. So is it being enforced?
July 5th is the enforcement date set in law. I've spoken to that is the go live date. So if you want to get compliant in advance of that date, please reach out to me now. Also, don't feel that you're too late. I can tell you that this has been the busiest week we've had, and I expect next week is going to be the busiest week we've had. Right now, there's a lot of people that are hearing about this law, figuring out how to get compliant. Now is the time.
Great. Zachary Long, thank you so much for telling us about this. It's been enlightening, and I wish you the best with your startup.
Thanks, Miles. Talk to you guys soon.
Okay. Thank you all.